You know, one of the most common questions or series of questions I get is always surrounding earnest money. Well, first, what is earnest money? Do you have to provide earnest money? How much should we provide? These kind of questions are very common. And, I got to tell you, and I've listened to obviously a lot of YouTube videos where others have explained the purpose of earnest money. And I got to tell you, I don't agree with hardly any of it. I understand what they're saying, but there's a lot. It should go a lot deeper. So anyway, we want to take a look at, first of all, what is earnest money? Well, and here's a definition, a legal definition. It says a sum of money paid by a buyer at the time of entering into a contract to indicate the intention and ability of the buyer to carry out the contract. Now there's several parts to this definition here, and this was the first part. Now let me just sort of go through them real quick, but that's the first part. But then it says it's normally such earnest money is applied against the purchase price or buyer closing costs. What they're saying there is, obviously earnest money is some amount of money that the buyer, when they make their offer, will put into the offer, be included in the offer. Just some amount of money that goes with it. But then what happens to this money? And what it's saying here is, assuming the buyer buys the house and we close, then whatever amount of earnest money the buyer put up, it'll just be applied towards the purchase price or closing costs or whatever. So it's not like the buyer's losing the money, assuming they buy the house. But then the next part of this definition, it says often the contract will provide for forfeiture of this sum if the buyer defaults. And what I was saying just a second ago, assuming you close, you buy the house, then that money will be applied towards your cost, your purchase price or whatever. But if you don't buy it, and the reason you're not buying is due to buyer default. In other words, buyer, it's your fault. Whether you just decided I don't want the house anymore, or you did something to cause the deal not to happen. Anyway, buyer, it's your fault. It means you're in default of the contract. Then you could lose this money. Now, and I'm saying you could. So I want to be careful here. But if the buyer loses the money, obviously it goes to the seller. Well, what's the purpose of it? And that's the key of what I want to do this video for. What's the purpose of this earnest money? And you'll see in this last bullet here, it's to be used as liquidated damages in case the buyer should default. Now, let me just say, here's what you tend to hear a lot. In fact, it seems like when I ask real estate agents this, and I'm not veteran agents, what is the purpose of earnest money? And I'm telling you, I get pretty much the exact same answer every time. And you see it on a lot of the videos, if you watch a lot of these YouTube videos from various people. But the answer you tend to get is the earnest money shows how serious the buyer is. It lets the seller know how serious the buyer is when it comes to buying the house. Obviously, the more earnest money you put up, the more serious the buyer is. Hopefully that gives the seller more comfort, I guess. Yeah, look, I understand why you would say that, but there's no legal basis for that answer as far as I'm concerned, not that I can see. And obviously, if we're going to be practicing real estate and dealing with contracts of sale, you need to understand that there's got to be some legal basis for these provisions within the contract. And obviously, within the contract, that's one of the provisions on whether or not you're going to pay or offer earnest money. How much is it going to be? And those types of things, which we'll look at. But so are you telling me if I'm buying a house and I put up $1,000 earnest money, for example, But then another buyer makes an offer on the same house and he puts up $5,000 earnest money. Are you telling me that other buyer, because he put up $5,000, is more serious than I am because I put up $1,000? Y'all, that's nonsense. That is, in my opinion, that is absolutely nonsense. Just because they want to put up more money does not make them more serious about buying the house, right? There are other things that I think we need to look at in the offer from the seller's perspective than the earnest money. I really do. And we'll talk about maybe some of that in another video. But right now I want to make sure we understand this earnest money thing. Y'all, look, the legal reason, the purpose of earnest money is to be used as liquidated damages in case the buyer should default. In other words, buyer, if you back out of the deal, you just walk away from the deal, then you could potentially create damage, financial, monetary damage maybe. And quite frankly, it doesn't even have to be monetary damage. But anyway, you've created an issue for the seller now. Should the seller be entitled to some kind of restitution, if I use that term? And I will tell you, that's what the earnest money is for. Seller will keep the money. Hopefully that will cover their loss, whether it be a monetary loss or just pain and suffering or whatever the case may be. Because you might say, well, but they didn't have any monetary loss. Why should they have the money? Well, I may not have had a monetary loss, but I had to take my house off the market to accept your offer. And now here we are maybe several weeks later, and now you're telling me you're not buying the house. So now I got to put the house back on the market, look for another buyer. That's costing me a lot of time. So even though I may not have any monetary loss per se, I have lost because of time, right? I've got to start over again. So what are liquidated damages? That's the next thing we need to kind of address real quick. So I actually pulled up the definition of what liquidated damages are. Excuse me. And that's monetary compensation for loss, detriment, or injury to a person or person's rights or property awarded by a court judgment, or, and here's the key part of the definition we're concerned about, or by contract stipulation regarding breach of contract. And that's exactly what we're talking about here. It's a contract stipulation. It's a provision in the contract that says if the buyer should default, meaning they don't buy the house due to some fault of their own, then the seller would be awarded the earnest money as liquidated damages. Again, compensated for a loss or detriment or whatever. So that's what we're talking about here. That's what earnest money is. In my opinion, it's got nothing to do with how serious the buyer is. Now, unfortunately, that's the way a lot of sellers are thinking because that's what real estate agents are telling them. So you got to keep this in mind when you're practicing real estate. I know the seller is now going to be thinking the buyer that offers the most or puts up the most earnest money, that's the most serious buyer. And I'm telling you that's nonsense. But that's what the seller's going to be thinking because of, in my opinion, because of inaccurate information being passed on by their agent. So you got to keep that in mind, and I'll address that some more in here in just a second. So here are 3 questions that I always get, so let's go ahead and answer them. Does the buyer have to offer any earnest money? Do you have to put up some earnest money? And I will tell you the answer is no. There is no legal requirement for earnest money. Now I've actually had, and I will also tell you, now a lot of what I'm telling you here is also market driven. So some of what I'm about to tell you depends on market conditions. But if you're in especially a buyer's market, which at the time of this video, recording this video, we're in a big time seller's market still. But if it's in a buyer's market, I'm telling you, rarely does my buyer, if I'm representing the buyer, rarely do we put up any earnest money. Typically none. But there are reasons for it, and this is what you need to understand as a professional. I don't recommend we put up earnest money most cases in a buyer's market, because when you put that money up, there's a chance you'll never get it back. If something happens, you don't buy, we can't close on the house, there's a chance, buyer, you're going to lose that money. So as the buyer's agent, I have a hard time recommending they put money on the table that they might not get back if we don't have to. Okay, now sometimes the situation warrants where we need to do it, and we'll talk about that. But I've had agents call me, come back and say, Frankie, I got your offer, but you've got no earnest money here. You have to have earnest money for the contract to be valid. That's not true. That is not true at all. Now, not going over the contracts per se, but to have a valid contract, one of the requirements is there has to be some legal consideration, which means the price, it must indicate the price paid and or for love and affection. One of those two have to be there. But earnest money is not the consideration. The consideration is the price paid. So if I'm offering $500,000 for your house, that's the consideration. The earnest money is not consideration. It's not. Again, that's just there for liquidated damages if it should arise. So do you have to offer earnest money as the buyer? No, you don't have to. Okay, so let me just be clear there. But if you're going to offer earnest money, then here's the next question I get. Well, then how much should the buyer offer? And this is where I have a departure from, I don't agree with a lot of the answers I see, especially on YouTube. I'll see, it's usually 1% of the sales price or up to 10% of the sales price or some nonsense like that. But I will tell you, in the local market that I'm in, I can about tell you, every time we get an offer, the earnest money that the buyer puts up is going to be one of two amounts. And I'm just talking about the market I'm in. So every market's going to be different. But I would say 70, if not 80% of the time, it's $500 of the deals I'm involved with. If it's not $500, they might go up to $1,000, which I guess that makes them more serious, whatever. So when an agent, at least around here, gets the question from the buyer, well, how much should I put up? Well, I think $500, that's typical. That's what sellers would expect right now, or maybe $1,000, or whatever. Well, first of all, I would question that answer, but irregardless, whatever amount you recommend to your buyer that they should put up, you better pay attention to this third question, because this is the question the buyer is going to ask you. Why should I offer that amount? So if you're telling me $1,000, then why? I'm not saying I shouldn't. I just, as the buyer, I just want to know why. Why am I putting up $1,000? And I'm just going to tell you, if I ask my agent this and they can't give me a pretty clear answer and a very definitive answer so that I'm comfortable in why I'm doing this, I'm having my doubts on, is this the right agent for me, quite frankly. And I will also tell you, if your answer is because that's what everybody else does, that's what's most common, that's what's typical, you see, your alarm bells are going off for me again. I want to know why you're suggesting I put up whatever amount you tell me to put up. Okay? So, look, here's what you need to consider when it comes to earnest money. Let's say I'm the listing agent. Obviously, that means I'm representing the seller. Earnest money, that's way down on the totem pole for me when I'm looking at things in the offer. There's a lot, in fact, almost everything else in the offer to me as the listing agent is more important than the earnest money. Unless I see something, one thing in particular in the offer. If I see anything in the offer that's going to require my seller to come out of pocket prior to closing. They got to pay for something, buy something prior to closing. Now you've got my attention. And now the earnest money becomes important to me. Because see, and I just give you this example. Maybe the buyer wrote in their offer as part of one of the stipulations to buying the house that the seller must agree to replace all the carpet in the house of the buyer's choosing. I know where the buyer gets to choose the carpet, but seller, you have to pay for it and you got to replace it. And all that's got to be done prior to closing. I'm telling you, stuff like that is not uncommon. You see stuff like that. And let's just say it's going to cost $5,000 to replace the carpet. Well, if I'm the listing agent, guess how much earnest money, assuming we agree to do that, we as being the seller. If we agree to replace the carpet, guess how much earnest money you're going to be putting up, buyer? $5,000. Again, the purpose of earnest money is to cover the loss or liquidated damage. You ought to cover the loss to my seller in case the buyer should default. So why would we accept an offer with $500 or $1,000 earnest money when based on the offer, if you walk away, it's clearly going to cost me a minimum of $5,000. So that earnest money is not going to be enough to cover my loss if you default, right? So y'all, this is what earnest money is to be used for. It's to cover those liquidated damages. And if you're representing the seller and you don't pay attention to this kind of stuff, your seller's going to be, in this example, if the buyer walks away, you got new carpet, but remember who picked out the carpet? The buyer. And it's probably a color or scheme or something about that carpet that nobody else is going to want. So you're probably going to have to replace it again. Or come off the contract or whatever, but it's going to cost you money. So look, the only time, at least for me, earnest money is important, from the seller's perspective, is if you're asking my seller to come out of pocket prior to closing. Because if we're going to have to pay or buy or do something prior to closing, you're going to have to pay for it yourself, buyer, if you don't buy this house. That's what the earnest money is going to be used for. Now, we'll also tell you where we tend to negotiate earnest money even more is during the due diligence period. Say the buyer has a home inspection done and the home inspector finds issues with the house. Now, it depends on what the issue is that the buyer is wanting repaired, replaced, or whatever. If it's something structural or a safety issue, something that needs to be corrected, then you know what, seller, you need to fix that. End of discussion, as far as I'm concerned. But if it's something the buyer's asking that's mainly just something cosmetic, just something they don't like, and they want something different or whatever, and they want the seller to fix or replace whatever it is to make it what they like, then we're going to have to talk about the earnest money some more. Again, maybe it was $1,000 to do whatever the buyer wanted to do. Well, we're going to make sure there's another $1,000 on top of the $5,000 for your carpet. Now you're wanting me to do something that's ridiculous, in my opinion anyway, because it's just a cosmetic type issue. I'm not saying we won't do it, but you're going to put up more earnest money to cover that cost if you don't buy the house. So again, at the end of the day, the only time I'm concerned about earnest money is when the buyer is asking the seller to do things or take money out of their pocket prior to closing. And by the way, if I'm representing the buyer, I tell the buyer the same thing. So if the buyer asks me how much earnest money should we put up, I'm going to make sure we put up enough earnest money to make the seller feel comfortable doing the things we're asking them to do, right? Replace the carpet or whatever the case may be. At least they know that they'll get that money back. They're not going to lose that money themselves if my buyer should default. I hope that helps clarify some things. the main reason I'm doing this video and others kind of similar to it, as a professional, you got to stay away from coaching or advising your clients based on what everybody else does. You need to know what's the legal reason. There's got to be some legal basis behind whatever you're suggesting or recommending your client to do, right? Because if I'm that buyer or seller and I'm paying you all this commission, I expect you to know a lot more about real estate than what everybody else does. I only care about me, quite frankly. So hopefully that helps you out a little bit. I always want to end with a success tip, and today it comes out of Proverbs chapter 12, verse 1. Whoever loves discipline loves knowledge, but he who hates reproof is stupid. What they're saying is, learn to accept criticism. That's the key to success. Listen to what other people have to say. But if you're going to get mad, you're going to reject it, that's what they're talking about. If you just can't take the reproof, that's just stupid. God bless. Have a good day.